Welcome to our presentation covering the topic of validating, or you might call it a citator lecture. This you'll find in Module 5. It's called Validating in our textbook. It's immediately below the midterm examination and above digests. Okay, so let's get started. You can see that we have 3 resources here. This is just a note-taking guide that may help you as you're reading the chapter. And we're going to focus on the PowerPoint today, and we're going to spend some time on Westlaw as well. This document right here is available to help you navigate through Westlaw as well. One thing you may want to do when we're getting to the Westlaw portion of the presentation is to pause me periodically so that you can keep up to speed with me as I'm going through the Westlaw part. If you're doing it at the same time I'm doing it, it's more likely to stick. And it may also help you form questions. Hey, I don't know why you clicked there now that I'm doing it myself. And then that would be a great time for you to reach out to me either during our virtual class hours or um, uh, to visit my office hours or email me. So those are some options here. If you also want to look for a written form of these instructions, this is a good resource. And again, this is a document that you will find right here. So this is the same thing as this. Okay, now Westlaw is a moving target. It's constantly updating and presenting its information in different ways. And so some of the stuff on this PowerPoint is I've updated it for this lecture, but some of it isn't completely 100% exactly what you'll see when you go there. And if you go there 6 months from now, it'll look a little different than it does now. So the important thing here is to get the concepts, to get why you're visiting this said website, as opposed to focusing on, okay, I click on the 3rd item in this list and then I click on the 7th item. Know why you're clicking on what you're clicking, and then if they change the terminology a little bit or move that particular link to a different place, you'll be able to find what you need. So let's get started with the PowerPoint. So here we are talking about shepherdizing. My unit numbers have changed over time. Shepherdizing is the generic term. If you were to ask 100 legal professionals, probably 80 of them would call what we're going to be doing today shepherdizing. I would have said if this were 20 years ago, I would have probably said 99% would have said that. Key citing has caught up a little bit in terms of lingo, and people who do use Westlaw on a regular basis may use the term KeyCite instead of shepherdizing. They're exactly the same thing. You're just using 2 different tools for the same task. So it might be a little bit like if you're stirring some ingredients together. Well, maybe you use a metal spoon, maybe you use a wooden spoon. Well, you still call it stirring. You're still accomplishing the same task. So let's get started on shepherdizing. There's lots of different resources for this. The textbook is a great one. This lecture, this PowerPoint, the Westlaw notes that I published are also helpful resources. And of course, your own notes. As we're going through this lecture, pause me when you need to so you can take down the notes and the examples that I use. My recommendation whenever you're participating in an online course is to, instead of having to watch the lecture 3 times, to spend maybe twice as much time as you ordinarily would and take careful notes as I go through. And that way you probably won't have to watch it again. And so that kind of maximizes the benefit of the online class. In a face-to-face class, you can't stop me and say, okay, Griever, don't talk for the next 5 minutes because I need to catch up with you on my notes. But you can stop me here. So that's a little suggestion for you going forward. So we're first of all going to talk about why do we shepherdize? What's the reason behind this? The second is how do we shepherdize with books? And finally, how do we key cite with Westlaw? So why do we shepherdize or why do we key cite? The main reason we do it is because we have to. Law changes over time. There are lots of precedents out there, lots of judicial opinions that are no longer good law because either the legislature has come in and changed the law or a subsequent court has changed the law. We can't cite Dred Scott or Plessy v. Ferguson anymore, obviously. We can't cite a case that has been overturned, and we'll go through an example of that in a few minutes. But that when you go to the reporters, the published reporters, and flip through the book, you'll find these cases that are no longer good law, and they look like good law. There's nothing that changes in their appearance because they were published when the authors, or excuse me, when the publishers thought that they were always going to be good law. So as a result, we can't rely upon just going to the book and looking at the case to know whether it's good law or not. We need an up-to-date tool that will help us know what's happened to what people think about this case after it was published. And that's what Shepardize and KeyCite does. You can't publish a case that hasn't been Shepardized or KeyCited. That's just act as if that's a complete non-option for you. If you don't have time to Shepardize it, you can't cite that case. It's as easy and as hard as that. It's unethical, and it's a sanctionable offense for your attorney to cite something that he hasn't KeyCited or Shepardized. Another related reason that we Shepardize and KeyCite is to find related cases. It's a wonderful research tool, and I'll show you some ways that you can use it for research in addition to confirm that something is good law. Even if a case isn't good law anymore and you may feel like, oh, I just hit a dead end here, you can still use that site to find good law, because after all, a case or a statute is telling you that's not good law anymore. So you found something that presumably is still good law, that case or that statute. And so you can click on that case and you have a place to pick up your search for all the good legal leads that will get you the research that you need. So it can be used to confirm that something is good law. It can help you find related cases that will help enrich and deepen and broaden your research tools. So keep in mind, when people say Shepardize, it's like saying Kleenex. You may say, I need a Kleenex. You don't mean I need that particular brand. Or you may say, I'd like a Coke, but you're perfectly happy with a Dr. Pepper. You just want a soft drink. Sometimes we use name brands for that purpose. So just be ready for people to say Shepardize when KeyCite is every bit as good. This is a terminology thing that is related to the Shepardizing issue, but it's important separately. And I'd like to spend some time on this because this is one that many students struggle to distinguish between. We have two words that seem to be related, and they are kind of related, but have very important differences in their meaning. One word is the word reversed. The other is the word overruled. Probably in everyday conversation we use these the same. Let's say a kid wants to go to eat Mexican food. Well, his mother might reverse him and say, no, we're going to have hamburgers at home. Or maybe the father overrules him and says, no, we're going to get Chinese. We would use in everyday conversation both terms, and basically in that context, they're synonyms. In the law, though, they have a really big difference in meaning. And so I want to cover that. And when I use these terms, just be aware that they really have a different meaning, and to make sure that you're thinking about the meaning that's appropriate for this particular term. So reversed has to do with the case's direct history. Let me explain. A case, starts in the trial court, and then somebody appeals it, so it goes to an intermediate appellate court, and then it goes to the Supreme Court. And it may actually at some point go down to the trial court again, and then go back up and go through that process again. There are cases that maybe visit 10 or 12 courts if they're unusually complex. And so all of that trip with the same plaintiff and the same defendant we call direct history. It's what happening specifically to that case. And so when we use the word reversed, we're referring to that process. That case, one court is reversing another court, and both of these courts are handling that same case. So let's imagine it's Bob Smith versus Mary Green. So it's Smith v. Green. Well, at the trial court, the trial court judge awarded in favor of Smith. Well, Green appealed. Green won on appeal, and so the appellate court reversed. The judges on that panel are reversing what happened to the trial court. It's all the same case, so it's reversing the progress of that one case. Now Smith was the winner at the trial court. Now Green is the winner at the appellate court. Okay, so it happens to the same plaintiff, the same defendant, in the same case. The reversal obviously is going to happen at a higher court level. The higher court is telling the lower court, oh no, you cannot. That's not what's going to happen. Okay, so that's what reversed is. Now let's talk about overruled. Overruled doesn't happen with the same people. So when I had my example of Smith versus Green, and if it were to go the other way, if one won at one level, then the other one at another level, we don't use the term overruled. That's reversed. We use the term overruled when there is a different plaintiff and a different defendant. This can happen at a higher court level, or it can happen at the same court level. It will only happen after this case up here, that Smith v. Green case, has been completely and utterly resolved. There's no more litigation on it. We know who finally won. It might have been reversed several times back and forth. Smith won for a while, Green won for a while, and back and forth. But at the end, there's a final winner. Or at least there's a final resolution. Maybe they both feel like they've kind of lost at some point, but we know what the final result is. So after that result happens, there's no possibility. When there's a finality to it, nobody is going to go in again and say, oh, wait a second, 10 years have passed, everything's been resolved in the case, we were going to reopen it. I mean, it just doesn't happen. I mean, very occasionally in criminal cases when there's new evidence, but in civil cases, it just doesn't happen. Okay, so that's not an issue that happens with those particular litigants. But let's imagine that there's a case, Smith v. Green, and it established a precedent in a particular state. All the way up to the highest court, we'll say the Texas Supreme Court issued the decision, and we're going to call the precedent X. It decided that, I don't know, all redheaded people automatically lose. That's the precedent they established. And for 20 years after that, every time a redheaded person sued or was sued, he knew he was going to lose because that's what this precedent said. Obviously, I'm being ridiculous. It's a ridiculous precedent, but just imagine this was the precedent. And so 20 years have passed. Smith and Green may have both passed away. In any event, whatever happened with them has been long since settled. But now a courageous redheaded person comes forward and says, well, I think that this precedent from 20 years ago is wrong, and I'm going to challenge it. And so he loses at the trial court level because there's this long-standing precedent that redheads always lose. He loses at the appellate court level because, again, long-standing precedent, redhead never, ever wins. He gets to the Texas Supreme Court, the court that initially reached this decision 20 years ago that was so bad for redheads. And the court hears this redheaded person's case, and you know what? The court says, we're going to revisit that decision. And so now the court says, we're not going to consider the color of people's hair when we rule on their case. It's not a relevant fact. And so we are now overruling that precedent from 20 years ago. Now, does it change anything with Smith and Green? Of course not. Their case is final. Once a case is finally resolved and all the appeals are done, we're never going to reopen it. Again, except in some very unusual criminal cases. But even those are really, really rare, and certainly not in civil cases. So whatever happens in an overruling, it's not helping Smith or Green. I mean, unless they get involved in some subsequent litigation that new finding might be relevant for. So when we have overruling, we're looking at different plaintiffs and different defendants in a different case, could be decades or even 100 years later. It's only going to happen at a court at the same level as this highest court or at a higher level, because again, we have this longstanding precedent. A lower court doesn't have the authority to overrule a precedent, and so it can't be a lower court than this highest court that reversed or made this decision. Again, of course, after this other decision, whatever's being overruled is final, and it doesn't affect the original plaintiffs or defendants at all. So my task, my request for you is that you spend some time thinking about the difference between reversed and overruled. Make sure you're clear about when to use the term reversed and when to use the term overruled, because this can be a source of great confusion for folks, and I want you to avoid having any confusion on this point. Let's go to our next slide. Okay, so when do I Shepardize? I'm involved in a research project. What's the right moment? I'll tell you practically, honestly, most people Shepardize at the end. But that's not the best course of action, because if you Shepardize at the end and you've been relying upon cases that were overturned, you're going to have to completely restart your research. And so that's not a very smart way. If you aren't 100% sure this case is good, early on you don't want to look it up. You probably don't need to Shepardize at the very, very beginning when you're accumulating your first resources, except if you're doing your research on Westlaw, it's super easy to Shepardize, and so it's almost organic to the research project to Shepardize. And so I would recommend do it earlier, do it often, as you are finding new cases. Don't see it as maybe a separate event that you do at the end. See it as something that you do as you find cases. You pull up the research and find out what's going on. Because again, Shepardizing and key citing can help you find new cases that will help your research project going forward. If you do a long-term research project though, and let's say you started your research 6 months ago or 3 months ago, you will want to go back and just confirm everything is still good law at the end of the project. That's kind of the historical reason people wait to the end, because they want to make sure they have the latest and greatest Shepardizing. If you're doing it within 2 or 3 days or a week, you're probably okay not Shepardizing it, unless you have some reason to think that there's a lot of flux in this area of the law. How much is enough? You will see in some of these cases that there might be thousands of cases that shepherds will pull up. You're not going to have time to look at them all. You're not even going to have time in every case to look at all the negative ones. So you have to use some good judgment. When we go into KeyCite, I'll give you some criteria to look at. But one thing to look at is how negative is a negative reference. There are differences. It's not just, all green and all red. There's shades of red and shades of green. You'll see what I mean in a second. And so you'll look for the most negative. And then you'll also look at what the court is. Montana Supreme Court that's very negative about a Texas Supreme Court case. From my perspective in Texas, I don't care what they think about us in Montana, right? But when a Texas Supreme Court is negative about a Dallas Court of Appeals, yeah, I care a lot about that. I'm definitely reading higher court's negative comments when that higher court is within my jurisdiction. So those are some things to think about. How negative is negative? Is that court a higher court than the case that I'm looking at? Is that court within my jurisdiction? And what's the year of the negative comment? Some things to think about as you sort through it. Positive treatment you probably never have to read, but it can be a really good resource to finding new cases. And of course, sometimes cases are kind of not categorized into negative or positive treatment. They're just kind of treatment. And those can still be helpful if you're looking for more case leads. This is what shepherds look like in book form. Typically, back in the good old days, when we had to do this process by book instead of online, you would go through several volumes of these are kind of burgundy, you can't see the color that well, and then multiple copies of the yellow and then the red. To Shepardize a single case with books could easily take hours if you were having to look up the cases and evaluate them. Now with online tools, what used to take hours, and I'm not exaggerating when I say hours, what used to take hours can now be done in 5 minutes. It's just a completely different game. Almost no one uses paper shepherds anymore. Even large law firms don't have paper shepherds anymore. It just doesn't make sense. It's much too time consuming to do it. And so I wanted to show you what the books look like. And here is information about the process, I kind of describe it a little bit, just kind of for your FYI. I don't expect you to know it. The only thing that I want you to know is that shepherdizing by paper is very time consuming. That's the takeaway. So again, all this information about how to do it with the book form is just for FYI, so you have a point of perspective as you deal with older paralegals and attorneys. This is what a page in the book looks like. And again, it looks almost like hieroglyphics or something. It doesn't really look like English, because in order to get as much data as you can in a book, they use a lot of abbreviations. So anyway, this is a kind of a blown up example of what it looks like. Again, don't need to know this. What we care about is online. And again, the two competitive products out there are Shepardize and KeyCite. Really, no other company has a true citator. I've seen some people use other tools um, uh, that you can use. It would be much more time consuming, and it require a lot more effort on your part, but it's possible to do it with some other online tools. But certainly the best plan of action is to use Shepardize or KeyCite. They're both equally good, and they're both very similar. In whatever your firm happens to have, most firms either have Lexis or they have Westlaw, especially if it's a smaller firm. And so whichever one your firm has is the one that you'll use. Usually Westlaw and Lexis these days have an unlimited kind of membership. And so you can Shepardize or KeyCite as many things during that month as your firm wants to. It used to be back in the day that there would be a significant charge for each shepherdizing that you did, but that's not true for most fee plans. It's always a good idea, though, to understand, at least in general terms, what your firm's Shepardize or a Westlaw subscription is like, so you don't inadvertently run up a bill that you didn't mean to. When you're shepherdizing, obviously, it may not be more expensive to shepherdize 20 cases versus 10 or whatever, but because Westlaw isn't going to charge you more, or Lexis isn't going to charge you more, but your time is money. And even though these resources may be free, your time isn't free. You're probably billing it, something like $100 to $200 an hour. And so if you spend an extra hour shepherdizing in an inefficient way, that's $100 or $200 that your client's going to need to pay. So it's a good idea to be aware, always be aware, obviously, that time is money in this particular industry. Well, in this course, we don't have access to Lexis, so we're not going to worry about knowing about online Shepardize. We're going to focus on Westlaw. I would say most people prefer Westlaw to Lexis, and I wouldn't say they prefer KeyCite to Shepardize. They're probably about equal, but certainly KeyCite is every bit as good as Shepardize. So I'm going to show you a little bit about KeyCite. If you know how to KeyCite, you'll be able to figure out Shepardize really quick. These are the Shepardize warnings that you'll see, and they're very analogous to the KeyCite warnings. KeyCite uses a flag system. Red flag means bad law. You can see they use a kind of a stop sign, warning, negative treatment. KeyCite uses a yellow flag for kind of danger or peril. And you can see that Shepardize uses a yellow triangle to mean caution. And there's some other little bit more granularity perhaps in the Shepardize version than in the KeyCite version. So these are just some points of reference to keep in mind. Know what the symbols mean, whichever system you're going to use, obviously. KeyCite uses bars now more than stars, so I've kind of changed this, or I've changed the terminology to bars, but they used to use stars here, so just imagine bars. The more bars there are, the more helpful the case is going to be for you. There's a more extended discussion. So you would prefer to go for cases that have 4 bars or 3 bars over cases that have 1 or 2 bars. But again, beggars can't be choosers. Sometimes all you'll see are cases that have 1 or 2 bars, and so those are the ones you're going to go to. But this at least helps you sort the ones that are highest priority. These are some ways of, because again, within that yellow flag and red flag terminology, Westlaw does offer more granularity, and you can see this one. We have superseded by law as stated in. So when something is superseded, you can't cite that. That's going to have a red flag. But in addition to having a red flag, it's going to have this description associated with it. In a way, if it has a red flag, you don't necessarily care why it has a red flag, but when you get into more of the yellow flag territory down here, there are degrees of yellow. You might say some are very light yellow, almost good, and then some might be, you know, kind of a burnt orange yellow almost, and those are the ones of heightened concern. So you do want to pay attention. Not all yellow flags are created equal. And these are some examples of ways of charting them. And I've tried to sort these in the order of absolute worst to least negative, at least group them in general categories. So we're going to go through the process of key citing in a couple of minutes by going on Westlaw, but of course you're going to need to get into Westlaw. Now this key cite part is not really necessary anymore, so let me go ahead and click out of that. You really don't need to use KeyCite as a separate tool in Westlaw anymore. So you can just go into Westlaw and enter into that big search box the name of the case or the citation that you're looking for. It doesn't have to be nice blue book format, just kind of throw it up there. And it can even be in the middle of the opinion. Sometimes you'll just have a middle of the page cite. Once you enter this, it will take you to the case. It won't take you to the key cite information at first, at least. And of course, the first thing you're going to want to do is confirm that you typed it in right and that you actually have the right decision. And then you will move forward from there. I'm going to get out of this for a second. Actually, let's see if there's anything else I want to cover in this document. I think the rest of the stuff I will just cover for you live in Westlaw. So just returning, if you have questions about how to use KeyCite in Westlaw, this document right here, which you can find right here, is really helpful. And then again, you may want to watch some of these things, this part of the broadcast or the taping again. So I'm going to go to home base. Here I am. And now I'm going to want to type in, I'm going to do two cases today. I'm going to do the Lilly Ledbetter case. So I'm going to go to the jurisdiction of the not the Texas Supreme Court, the U.S. Supreme Court. So I click on that, I save, I see my jurisdiction here. I'm going to type in Ledbetter. And you can see as I type, I don't have to get very far at all, and I can see the case that I'm looking for. So I'm going to click on this case. Where I find key cite information is above this line. So this line right here, things above it, this is kind of my key cite area. You can actually see they actually have powered by key cite. All of this stuff is key citing. It's not part of the published opinion. These are tools to help us decide whether this is good law or not. And you, of course, are immediately aware of the fact that you're looking at a red flag. This is not good law. You may think, well, how can that be? This is the Supreme Court of the United States. How could it ever have bad law? Well, very easily. There's two ways it could have bad law. One is a subsequent decision of the U.S. Supreme Court could overrule another decision. That's not what happened in this case. In this case, we had the Congress passed a law that overruled this decision. And you can see we see a red flag here. We'll also see a red flag over here. And this will give us this reason. Overturned due to legislative action. And it actually gives you the citation. So this case came out, this decision came out. The Congress said, oh, no, you don't, Supreme Court. We don't like this. They passed a law that changed the law. And then this decision became moot because it was interpreting a statute, but the statutory language it was interpreting doesn't exist anymore. Okay, So this is where we are. This is our field. And you can see up at the top, we have 6 different boxes: document, filings, negative treatment, history, citing references, table of authorities. You can see we're in the first option, document. I can click on the next option, filings, and it's going to go white, and all the other boxes go blue. So these are all of the documents that were filed, at least that Westlaw decided to put up. It's probably not all the documents, but some of the documents at least, that were filed in this case. So you can see this is a reply brief to the petitioner. Here's the brief for respondent. Here's a brief amici curiae of the EE Advisory Council. Here's this is what often is called an amicus brief. This is a brief of the Chamber of Commerce, all going down here. I don't know if we have access to any of these. I'm just going to click on one so we can see. A lot of times these are outside of our subscription. Looks like we do have access to this one. So this is the actual a document that was filed for the U.S. Supreme Court to read and to consider before it rendered its decision. This can be very helpful for you in seeing the names of cases that might be relevant, arguments that were powerful, and it can help you. And it's just usually, since this is the people at the very top of the legal game, because it's before the U.S. Supreme Court, you'll read really, really lovely legal writing. So this can, if you're researching this particular issue, these can be helpful. They're probably not the first place I'm going for assistance in a matter, but they definitely can be helpful. So we've looked at the document, which is literally let me just go back and explain. This is the literal opinion that the U.S. Supreme Court issued, and we can see it begins right here. We can see Justice Alito delivered the opinion, and the actual opinion starts right here. So the actual opinion is here. The documents that were filed before this opinion came out to influence or persuade the Supreme Court were filed here. Now we have negative treatment. That's really what the red flag is all about. And when people talk about key citing or shepherdizing, this is the section they're really focusing on. What bad things? It's almost like gossip if you think about it. You know, there's a line you may have heard: if you have nothing good to say about somebody, come sit by me. You know, the idea, I want to hear all the good gossip. Well, this is the good gossip place. You'll see what people say. And so you can see this one has a red, and you can see why. It's overturned due to legislative action. And they'll even tell you it's most negative. They put the most negative stuff here, at least in their opinion, the most negative. And then you can see here, superseded by statute as stated in. And all of these have the exact same language. Superseded by statute, superseded by statute, superseded by statute. You usually won't see this many say the same thing. That's a little bit unusual. Let's see if we can see any other ways that it's described. Probably not. The statute came so soon after the decision was published that pretty much everything is going to say that. Anyway, so you can see we have 100 and they all say exactly the same thing. We could, let's just pick this top one here. You can see this is from Middle District of Florida Trial Court, District Court. I'll click on this and it'll take us to the case. Bush v. Orange County Corrections Department. And we can scroll down here and it will show us the case, Ledbetter. You can see here, OCCD asserts that plaintiffs' Title VII claims are untimely. Plaintiffs complain about demotions and pay reductions that occurred in 1990, 16 years before the suit was initiated. In Ledbetter, blah, 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 the Supreme Court held the EOC charge alleging disparate pay under Title VII must be filed within 180 or 300 days of the discrete pay decision, even if there is alleged to be a continuing resulting pay discrepancy years later. Under Ledbetter, blah, 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 the claims would be barred. However, the Ledbetter decision prompted a congressional response, and just last week, the president signed this law into effect. And so Ledbetter is no more. in terms of a precedent. So I'm going to click back. So you can see clicking on the case is going to let you find precisely where it's in play. I'm going to actually click on the little yellow flag. Oh, okay, sorry about that. So that gives you the Shepardizing for the Bush case. So the Bush case has some question marks about it too. So this flag, the yellow flag is for Bush. The yellow flag is not for Ledbetter. And you can see over here we have 3 bars. So this is a pretty in-depth treatment. Let's go down here though. We can see one case with 4 bars. That would even be a more complete treatment. We wouldn't be very interested in looking at this case for a discussion about Ledbetter because you can see it has a red flag itself. Plus it only has 2 bars. Since we're seeing lots of cases with 3 and 4 bars, I would probably focus on the 4-bar cases. I might also be interested in cases that are in my jurisdiction. And you can see here, we haven't had a lot of cases in my in Texas. Let's see here. Not that it's really that relevant because this is a federal law, but we have one here. There's a yellow flag. We have 3 bars. I might be interested in looking at this case, citing this particular authority. It's out of the Western District of Texas. We have the Southern District of Texas here, but we have a red flag there, so I'd be less interested in looking at that case. So you can see how I sort through things. Here, this is a state law case. Less important because this is a federal law, so we're not nearly as interested in what a state court says about it. Plus, we have a red flag on it, so not that interested in it. This case was never published because all we have is a Westlaw site, so I'm not very interested in citing that too. Generally, you can't cite unpublished sources, or at least you have to put a lot of caveats with it. So far, I'm not too excited about that citation. This is nice that I could get a circuit court decision, but this isn't my circuit court, so I'm not too thrilled about that one. Here's a state, again, a Texas state case, but again, since we're talking about federal law, I don't care about that. Here's the DC Circuit. Might consider using that if I can't find a 5th Circuit. Here's a 7th Circuit. Good. Here's a 9th Circuit. 5th Circuit courts aren't too interested in the 9th Circuit here. There's kind of a bit of a rivalry. 11th Circuit. I might go for that if I can't find a 5th Circuit. Here's an Eastern District of Texas. That's where Collin County is. And we have 4 bars. So Whitworth might be a real good choice. So hopefully you're getting a sense as to how I go about doing this. Here is a Texas Supreme Court. Obviously the highest authority in our state, but this is again the law is a federal law, so not as relevant. So wouldn't be as interested in doing that. Here's an Eastern District. And you can see what I do. I mean, I don't know, there might eventually be a 5th Circuit here. I'm not going to continue to go through it. But what we're interested in is if we're looking at a federal law issue, we're looking for having a federal court. If it's a state law issue, we're looking for a state court. We would ideally like either a U.S. Supreme Court, which we're not going to have in this case because the new statute hasn't been revisited by the U.S. Supreme Court, so we don't actually see the U.S. Supreme Court ever saying, hey, our previous decision was superseded, even though it's not debatable. It's very clear that it was superseded. So 5th Circuit would probably be the highest we could get. If we can't get that, a district court from Texas, or maybe a circuit court, another circuit court might make sense to substantiate that. So that is the negative section, okay? Now, as you can see, we literally have 219 in this category. There's no way we're going to look at very many of these at all. In fact, I would say you probably could look at 1 or 2. and feel very satisfied that we're done looking at this, because we know this is not good law. We shouldn't be citing this case. So now we're going to go to history. This is a picture of the progress of this case. You can actually see another picture of the progress of the case of another case here to show the progression. So this is another example if you want to kind of spend some time looking at this. These can get rather involved. The one that's in yellow is the actual opinion that we are shepherdizing right here. This opinion is also published. We could go to it and we could go to this decision. So let's just do this for a second, just so you can see. I'm going to go to this decision, which is out of the Northern District of Alabama. So I'm going to click on this. We're going to go to this decision. We can see again there's a red flag here. Now I'm going to click on history here. You can see it's Northern District of Alabama, decided in 2003. Click on the history and we're going to see, this case down here is now the one kind of in yellow. This is where we were before and it's not. So I'm going to go back to where we were before and click on the history here. So sometimes what happens is you have a case and you're not quite sure where it is in the pipeline. You might stumble onto this case and you want to see kind of graphically, it's a little easier to sort it out. You can see, oh, wait a second, this isn't the final case. I for sure want to look at the final resolution. And so that's where you want to be here. So usually you're going to want to be at the top or the end of the road. It's almost like a path to get to. In this case, we have a red flag on our path, so it's not that helpful. And again, here's a list of other aspects of these same connections. See, this is in yellow, this is in yellow. If I click on this and go over here, this is in yellow, this is in yellow. So that's a little graphic representation. Citing references give us non-negative. I'm sorry, I'm in the wrong. I'm in the wrong thing here. Let me go to this case. Sorry about that. So you always have to kind of check, am I in the right case? And you can see I'm back in the U.S. Supreme Court. So citing references is huge. This is going to be much larger, almost always the negative treatment. This is a subgroup. And you can see it's broken down into cases. There's over 1,000 cases to look at. Trial court orders, administrative decisions, administrative filings, secondary sources, practical law, lots of different things. There's no way, I mean, unless you were spending your whole life just focusing on this one case, that you're ever going to look at all these resources. Let's just look though and see kind of what we're looking at here. So these aren't going to be just negative. They're going to start with the negatives, sure. And then they're going to go to, you can see the next treatment that they have here after superseded. Then they have not followed on state law grounds, declined to extend by, distinguished by, that's a very common one, examined by. See all these different words that tell you the level of review. And you can see over here, examined by, not surprisingly, it has 4 bars. So there's lots of discussion about the case. Superseded by statute, we've seen that one before, right? So you can see we see the cases that we saw here also over here, but we'll also see positive treatment if there is positive treatment. I'm just going to click on, we'll see on number 4. We're still, obviously this case only really has negative. Here we have some there. So cited by. Cited by usually means it's just a brief reference to, so we're usually going to see a 1 or 2 here. But this isn't negative treatment. And some of these cases might actually have cited to Ledbetter before the Congress changed the law, for example. Okay, so this gives you, so let's say that we know Ledbetter's bad law, but we want to find out what the current law is. How can we use KeyCite to do that? Well, one thing is we can look at that statute. We can find that statute and uh, right here and look that statute up and find where the law has been overturned. Or very likely, these cases will cite the statute. I actually think that this case did cite the statute. We can also read these cases to see what the law currently is. And so there's lots of different ways of even taking something that is no longer good law and using it to help you find good law. So we've talked about document, filings, negative treatment, history, citing references. Our last choice is table of authorities. These are the sources used by the judge who published this opinion. So Judge Alito cited all of these cases in the opinion. Now, obviously, he's not going to be able to cite any of these cases. He didn't have a crystal ball. By definition, these cases had to come down after a Ledbetter. Obviously, in the table of authorities, this statute's not going to be cited because the law was passed after this case. You can see this decision came down in 2007. This law was passed in 2009. So this, again, can be a good source of leads for finding cases that you might find beneficial to cite. Okay, so that's what I wanted to cover with respect to Lilly Ledbetter. I wanted to show you an example of something that had been had a red flag. Now I'm going to go back to home base and I'm going to switch our database to Texas. We don't need the federal court, so I'm going to make it just Texas. I'm not going to click on that. And I'm going to type in, this case is Austin v. Kroger. And you can see it pops up here. I'm interested in the Texas Supreme Court case, so I'm looking for TEX. This is the one I want. This is the case. I'm going to confirm it's right. Yep, that's the citation I was looking for, Texas Supreme Court. That's the year the decision came down, so this is good. I might even just double check and look at the, read this, see, oh yeah, this looks right, this looks right. Okay, so now I'm going to look at, again, our KeyCite section here, this very top of the page, and I see that there's a yellow flag. I'm going to tell you a little secret about yellow flags. Most important cases, in fact, I would say virtually all important cases have yellow flags. Because a case can get a yellow flag for very innocent reasons. Let's imagine that there's a really strong precedent out there. Everyone agrees this is completely good law. But you know what? Even the best case doesn't apply to every fact pattern. So it could be like, for example, Brown v. Board of Education. Everyone agrees that's completely good law. We've integrated our schools. Separate but equal is no longer the law of the land. But if I were to cite Brown v. Board of Education when I get into a car accident, the court would rightly say, yeah, Brown v. Board of Education is an amazing lawsuit. It's good law. We love it. But it has nothing to do with car accident cases. It's not relevant to your dispute, ma'am. And they would be right to say it. So what they would be saying is this case is your case is distinguishable from the facts of Brown v. Board of Education, because Brown v. Board of Education had to do with integration of public schools, and your case has to do with a car accident. So no relationship between the two of them. Well, when that decision is published, it's going to get a yellow flag because the judge distinguished, or Brown v. Board of Education would get a yellow flag because my judge in my case would be saying, I'm distinguishing Brown v. Board of Education from your fact pattern. So the yellow flag really catches a lot of things that really aren't negative connotation. So don't get worried about seeing yellow flags. It's really a fairly harmless sign. Now, I mean, it can mean there's problems, but don't get too worked up if you see a yellow flag. Okay, see, we have the same things here that we had in, well, really for any KeyCite. We have filings, so we can see all the different documents that were filed in this case. We can see down here is the appellant's reply brief. Let's see if we have access to that. Oh yeah, we do. table of authorities. This one might be a little bit less awesomely written. I mean, it may be good, but it may be a little bit less awesomely written, although it was written by an attorney, than you would find in the things in front of the U.S. Supreme Court. It's kind of interesting sometimes to look at these, to read these, to get a feel for the law. Let's see if we can find Kroger's. Kroger's is probably more likely to have a team of lawyers on their case. Let's see. So they have Briscoe's a prominent lawyer. Not super familiar with that law firm. I've heard of Briscoe. But anyway, so here are the filings. So again, if you wanted to see the things that this particular court, the Supreme Court, reviewed before issuing this decision, here they are. At least many of them are. You can also find this obviously on the Texas Supreme Court's website. These documents are oftentimes available there. Here's negative treatment. We only have 2 here, so that's good. We see decline to extend by and decline to extend by. These do merit a yellow flag, but they're really minor. And you can see this is from the Northern District of Texas. So this is a federal court. So when it's a state law issue, federal courts have no business saying our Texas state laws are wrong. That's not something that they would feel empowered to do at all. So we know they're not saying we disagree with the laws of the state of Texas. No, they're a federal court. That's not their business. This court is an appellate court in Texas, so it is lower in seniority than the Texas Supreme Court. So it's not going to say the Texas Supreme Court completely messed up, they're completely wrong, this is a stupid decision. They're not going to do that. The Texas Supreme Court is not exactly the boss of these justices, but that's kind of a helpful way of looking at it. Are you really going to slam your boss, publish an art? No, you're not going to do that. And so these 2, though they merit the yellow flag, are very mild things. And so you can see we get the most negative here. Let's just go into that and see what the negatives look like. Oh, here's another thing I wanted to show to you. We see over here some numbers. These are the head notes in the Advanced Tire and Wheels case that reference the subject matter of Austin v. Kroger. 7, 22, and 30. We can see what the key numbers are about. We've talked about key numbers before, and so this kind of helps you figure out kind of what's going on here. I'm actually going to click on the case though. And I can scroll down. I think one of the numbers was 7. So I can click on this right here and go to that part of the opinion, and you can see actually it's more 8 than 7, so maybe I miscalled that. You can see we're in the section where we have a lot of stuff about Kroger. Let's just read it here and see what this quote-unquote negative comment about Austin v. Kroger is. Just as landowners owe a premises liability duty to invitees on the premises, employers have a duty to provide their employees with a reasonably safe work environment. And e.g. means for example. But employers' duties to their employees in this regard are broader than their premises liability duty to make safe or warn against any concealed, unreasonably dangerous conditions of which the employer is aware, reasonably should be aware, but the employer is not. Again, check out the Austin case. The additional responsibilities of the employer to its employees include a duty to provide necessary equipment, training, or supervision. Again, a reference to Austin. And then we'll just skip here. Contrary to Advanced Tire's assertion, an employer does have the affirmative duty to furnish reasonably safe equipment necessary for the performance of the job. And again, Austin is cited. So far it seems like a really positive take on Austin. Let's go on and read some more. Ultimately, Advanced Tire's argument that in Shakir, expertise may be reduced to the contention it owed him no duty because he recognized the risk imposed by the task and he could have refused to perform had he felt it was too dangerous. See the Austin case. An employee always has the option to decline to perform an assigned duty and incur the consequences of that decision. But the Supreme Court's reference to this reasoning in Austin was made in the context of explaining why it would not recognize a new exception to the rule that employees have no premise liability to protect or warn an employee or invitee against unreasonably dangerous premise conditions that are open and obvious or otherwise known to the employer or invitee. The court distinguished premises liabilities claims from other types of work or workplace negligence claims, and it declined to decide which, if any, of the limitations of the employer's liability, premises liability duty applied to other workforce negligence claims. So basically what this court is saying is the Austin court refused to express an opinion on this particular issue. And a premises, and so they're basically saying, yes, some of Austin is very relevant, but it doesn't answer the question that we're here to answer. So it doesn't seem really like negative treatment at all. It's just describing Austin and saying that Austin doesn't really answer the question that we're facing. So yes, negative, but not negative in the sense that Austin isn't good law. Let's look at the history here. This is why I picked this case, because it's really interesting in terms of its procedural history. So here we are with the Austin case. Let's see where it started. We started in federal court in the Northern District of Texas. And then it went, then it went to we stayed in the Northern District of Texas, and they denied reconsideration. They said no, and they said no again. Then the case went to the Fifth Circuit. The Fifth Circuit affirmed in part and reversed in part. And then the court usually in this case, the court is going to remand, and it looks like maybe that wasn't published. So after this decision, probably the court remanded to the trial court again. And then it went back to the, but because that opinion wasn't published, there's no place to tag to it here. And then it went, after whomever won, the other person then goes back to the Fifth Circuit, and it's affirmed in part. But look, it sends a certified question to actually, this is the certified question here. It sends a certified question here. So after this, it sends a certified question to the Texas Supreme Court. So what is a certified question? Well, we've talked before how the federal courts can't make Texas law, and how Texas state courts can't make federal law. It's apples and oranges. And so when a federal court is confronted with an issue that hasn't been decided in Texas, but it's a Texas state issue, they have a couple of choices. One choice is they can just do the best they can and look at what authorities are out there and say, well, this is what we think the Texas Supreme Court would do. And honestly, that's a pretty common way for the court to handle it. But every now and again, especially when it's a major issue, the court will certify the question to the highest court in that state and say, listen, tell us the answer. Let's see if we can actually see the certified question. Court of Appeals, let's see if we can find it in here. So we're on number 10. We are persuaded that certification of the premises liability claim is the best approach, as there is arguably conflicting Texas Supreme Court precedent. As a matter of discipline, we survey the Texas law in this area, both to explain our uncertainty and assure that we seek certification only when necessary. We do not presume to instruct in our explanation, but to explain our difficulty and allow the only court empowered finally to state the law to do so. And so here is the certification. For the reasons explained above, we certify the following questions to the Texas Supreme Court. Pursuant to Texas law, including this labor code, can an employee recover against a non-subscribing employer for an injury caused by a premises defect of which he was fully aware, but that his job duties required him to remedy? Put differently, does the employee's awareness of the defect eliminate the employer's duty to maintain a safe workplace? So that's the issue that this court is directing to the Texas Supreme Court. Okay, so now we're back to so then it went to the Texas Supreme Court to certify the question. And again, the only thing they're answering, they're not resolving the dispute between Austin and Kroger. They're only answering the certified question. Oh, I'm second, I clicked on the wrong one. And you can see, concluding, it is best to leave the resolution of these matters to the good judgment of the highest state court. The Fifth Circuit certified the following question, and that's that question. And the rest of it is going to be to answer this question. I don't even know if it would be interesting to read this. I haven't actually, but I don't even know that the court is going to even talk about the underlying facts. They may just be answering that theoretical question. So you can see how the history is usually very straightforward, but it can also be quite involved. Now we're going to go to citing references. We only had 2 negative references, but we have 816 citing references. And you can see our negative ones are the first. We've already seen these before. Now we can see various levels of decision: examined, examined, examined. You can also see over here that if you're really interested in cases, they'll show you just the cases. There's only 114, right? Not a lot, no. Still a lot to go through. But maybe you're primarily interested in secondary sources. Well, there's only 81 of those. Maybe you really like ALR, American Law Reports. Or maybe you're interested in this practical law tool, which gives you an example of how to write a waiver and release. Or maybe you're interested in trial court documents. So all of these are in this category of citing references. Just gives you a little bit more granularity. I'm guessing in these secondary sources, there's probably some law review articles. Maybe I'm interested in maybe it's been in, let's see if they're going to list some things. Law reviews. If there were a long list, I might maybe I really want to look at Baylor. You know, obviously in this list it's easy to find the Baylor Law Review, but if there were, 50 things on this list, it might take a while to find it. So maybe I could go in and just find this. And again, table authorities are just what they were in the Lilly Ledbetter case. These are the cases that are mentioned in this decision. So we are kind of done with looking at KeyCite. You can see how it can be used to confirm that something is good law, and also can be used to find additional resources, including statutes, but mainly cases and secondary sources that will help you with your research. I'm going to go back to our initial PowerPoint here for just a second. And you can see some of these tools. These gives you the categories that we looked at when we were going through, at the very top of the screen. And this gives you an example of a procedural history chart. They've changed the appearance slightly. And then this gives you, again, it's changed a little bit, but it gives you an example of the listing of the cases. Again, in the olden days, they had those types of flags, not the style they have today. And then here are some descriptions of the various terms. This is how they group them within the various terms. If you have any questions about this material, please don't hesitate to reach out to me either during class or online or via email. Thanks so much for your attention and have a wonderful day.